1.
Okay, we're on page 18 of the 2021 new law update, and under the category of juveniles and juvenile code. And all of this material from this point forward was provided by Christine Tebow, who's an assistant district attorney and juvenile prosecutor in Cumberland County. And I'm going to skip over a lot of this and only talk about or make note of or red flag those areas that are highlighted because those are the most relevant to law enforcement. Most of these changes in juvenile laws, juvenile code are relevant to the courts and prosecutors, but I've included everything here for the benefit of whoever may be reading this law update, which includes prosecutors. So given that, we're going to go forward to page, let's see, we're up to page 20, looking for a highlighted section. On page 21, the first one that's highlighted is chapter 156, which enacts a new section of 20A, which are the education school laws. And chapter 156 requires school resource officers to complete diversity, equity, and inclusion training or implicit bias training at least once during that officer's first year of employment as a school resource officer. Chapter 365, this enacts many substantive changes to how juvenile justice records are managed and disseminated effective in January 1 of next year. And as you can see, it gets into the weeds there a bit, but the citations are there for you to take a look at. There's some change in definitions. There's changes in to whom these records may be disseminated. And then enactment of Title 15, Section 3010 creates an entire new section in the Juvenile Code to govern management of juvenile history record information collected by or at the direction of a criminal justice agency. And this is analogous to the Maine Criminal History Record Information Act for adults that's found in Title 16, Chapter 7. And again, it goes into some detail as to what that constitutes. An amendment to Title 15, Section 3007 specifies that law enforcement officers of the court, juvenile correction community officers, and other representatives of Department of Corrections may not disclose the identity of any juvenile involved in the juvenile justice system until a juvenile petition is open to public inspection. However, the identity of a juvenile may be disclosed to a victim, a criminal justice agency, or DHHS, regardless of whether a petition has been or will be filed. And then we have a couple of new sections, enactment of Title 15, 3308A. One subsection authorizes dissemination of juvenile intelligence and investigative record information to government agencies responsible for investigating abuse, neglect, or exploitation of children, or responsible for licensing child care facilities, family child care providers, or children's camps or their employees. And another subsection of 3308A that was enacted creates a new civil violation for unlawful dissemination of juvenile intelligence and investigative record information. Any person who intentionally disseminates confidential juvenile intelligence and investigative record information, knowing it to be in violation of any provision of this chapter, commits a civil violation for which a fine of not more than $1,000 may be adjudged. And that would be, the jurisdiction there would be the district court. And moving through, looking for another highlight, we're up to page 24. On page 25, we see number 19, an enactment of a new subsection of 3308C, creates a new civil violation for unlawful dissemination of juvenile case records, and essentially the same prohibition as we just went through any person who intentionally disseminates confidential juvenile information contained in confidential juvenile case records, knowing it to be a violation of any provision, commits a civil violation. And again, the jurisdiction is with the district court. And then on page 26, number 27, the enactment of a new section of Title 15 creates a civil cause of action for persons aggrieved by unlawful disclosure of confidential juvenile intelligence and investigative record information, juvenile case records, or juvenile history record information. An action may be initiated by the juvenile or the juvenile's parents, guardian, or legal custodian in the district court where the alleged violator resides or has a principal place of business. And then it lists the remedies authorized to include injunctive relief, reimbursement of court costs, reimbursement of reasonable attorney fees, actual damages up to $5,000, and punitive damages. And that completes the review of the 2021 new law update. And thanks to Dirigo Safety for providing this update to law enforcement, which, as you see, will be done through various means. And we're at an end, and thank you very much.